Well, thank you very much. Good afternoon, everybody. My name is Vince Farhat. I'm a partner at Jeffrey Mengels, and we want to thank the Beverly Hills Bar Association for the opportunity to meet with you today. According to Johns Hopkins University, as of this afternoon, there are about 5.7 million COVID cases worldwide, resulting in over 356,000 deaths. Here in the United States, there are almost 1.7 million cases, and over 100,000 Americans have died. And today is a grim milestone. We did pass the 100,000 mark today. I think it's fair to say that we live in unprecedented times, and never before in modern history has the United States voluntarily shut down our entire national economy in an effort to stop a virus pandemic. Entire industries are shuttered, tens of millions of people are out of work. Payrolls have dropped by over 20 million workers, which wiped out in a single month an entire decade of job gains. Manufacturing output fell almost 14% last month, which is the largest decline on record since the year 1919. Now businesses are starting to reopen. And as businesses are starting to reopen, governments at every level, federal government, state government, local governments are struggling to try to help companies and people in need. And we all know about the CARES Act. Last month, the federal government added another $460 billion in relief to the already passed $2 trillion in government aid. And as we speak, Congress is working on a package of further aid. Now, today's program is not about the economic challenges we face. This presentation is about the law enforcement investigations that will be ramping up in the near future. In passing the CARES Act, the federal government created enormous incentives for companies to apply for economic stimulus funding to alleviate the economic impacts of the pandemic. With trillions of dollars in government aid being dispersed, law enforcement agencies already have started investigating companies and business owners in connection with their receipt of stimulus funding and grants. We're going to talk about that today. For example, less than 2 months after the passage of the CARES Act, DOJ already has brought 8 or 9 criminal cases for alleged fraud and false statements in connection with the SBA's Paycheck Protection Program, the PPP program. And that's really just the beginning of what we anticipate will be years of government investigations and enforcement actions. Today's program is going to be in 3 principal parts. First, we're going to start the program with a focused overview of the CARES Act programs and the government oversight provisions that are included in those programs. Secondly, we'll talk about current trends in COVID-19 anti-fraud enforcement by federal, state, and local law enforcement agencies. And lastly, in the last part of the presentation, we'll highlight why companies receiving federal aid should be positioning themselves now to demonstrate compliance and manage enforcement and litigation risk. At the end of the program, we'll leave time for questions. We would ask you to share information or questions on the chat or Q&A function on your Zoom application, and we'll answer questions at the end. And if we don't have time to answer every question, we're always happy to take those offline. I'm joined today by my colleagues Justin Anderson and Sina Maximini. Justin is a member of our litigation group. His practice focuses on commercial litigation, corporate defense, and investigation matters. He earned his law degree from Duke University School of Law and attended undergrad at the University of California in San Diego. Sina is a member of our government group. His practice focuses on assisting clients in navigating regulatory, zoning, and environmental issues. He's part of the legal cannabis group as well. He earned his law degree from the University of California, Berkeley School of Law, where he served as a member of the California Law Review.
Now that we know what's happening in enforcement today, what can we expect from law enforcement in the near future? How can companies receiving federal aid position themselves to demonstrate compliance and manage enforcement and litigation risk? Vince will be answering these questions. So let me introduce Vince before he comes on. Vince is the chair of our law firm's White Collar Defense and Investigations Group. Before joining JMBM, Vince served an assistant U.S. attorney in the major fraud section of the U.S. Attorney's Office for the Central District of California. In that position, he investigated and prosecuted white-collar crimes, including healthcare fraud, bank fraud, mail fraud, wire fraud, bankruptcy fraud, every type of fraud you can imagine, and money laundering. Before becoming a criminal prosecutor, Vince was an AUSA in the criminal division in the Civil Division of the U.S. Attorney's Office, where he represented the U.S. in commercial litigation and other civil cases. He also served as a law clerk to the Honorable Edward Graffiti, a U.S. District Court judge for the Central District of California. I will now turn the program over to Vince.
All right, thank you, Sina. And if people do have questions, please feel free to put them in the Q&A, and we can break up the monologues here that we're doing. So what can we expect in the future? Obviously, one of the takeaways from this presentation is that there are significant strings attached to the receipt of federal relief funds. This is true whether it's a loan or a grant. Those strings can be very problematic. And to frame where we think this is going, we'd like to make the point that past is prologue, that old saying. Although this is an unprecedented pandemic in modern history, certainly we've seen other situations. We really can look back to the 2008 financial crisis to give us a sense of how enforcement may proceed going forward. Government financial fraud enforcement in the wake of the 2008 financial crisis is a good indicator of what we can expect. After the 2008 crisis, we all remember that Congress established a special inspector general for the Troubled Asset Relief Program. It was called SIGTARP. And SIGTARP was meant to deter fraud, waste, and abuse relating to the Troubled Asset Relief Program, which helped stabilize the country's financial system. Now, bear in mind, although at the time TARP seemed enormous, it made $700 billion available to stabilize the economy. That's really dwarfed in comparison to the amount of money we're talking about here, over $2.5 trillion. But through the Special Inspector General, through SIGTARP, there were a number of investigations that led to the recovery of about $11 billion and prison sentences for hundreds of defendants through the enforcement actions that were brought by a number of different regulators, including the Department of Justice and special inspectors generals. It was, the special IGs were set up to oversee billions of dollars of funds unrelated to the financial crisis, allocated for projects to rebuild Iran and Afghanistan. So you've got the SIGTARP prologue as well as the special IGs. And as the slide indicates here, these special IGs recovered nearly $200 million in funds and resulted in a number of convictions. We can expect similar, very rigorous scrutiny as to the funds that are distributed through the CARES Act. As with TARP and the SIGTARP investigations, businesses should expect strict enforcement scrutiny involving CARES Act funds for many, many years after the pandemic has subsided. Obviously, also, the amount of money involved in CARES Act is much bigger than TARP. We're talking about trillions, not billions. Another way to understand the sheer scale of the federal government's intervention in the economy in this pandemic and how it creates enforcement risk for companies is looking at what's being done by the Federal Reserve Bank. The central bank's portfolio of stimulus-related bonds and loans and new programs is estimated to grow between $8 and $11 trillion. That's with a T. And that's compared with less than $4 trillion last year. So a Fed portfolio in that range would be roughly twice the size reached after the 2007-2009 financial crisis and is nearly half of the value of U.S. economic output. So it really sort of boggles the mind, the amount of federal money going into the economic system. The Fed's corporate program of corporate buying is already starting to kick in. It started earlier this month. The central bank, for example, tapped BlackRock to help it direct money into both new and already issued corporate bonds. And this assisted the Fed in its new role as a lender of last resort. And that's a relatively new role for the Fed. The Fed also tapped PIMCO to help the central bank buy commercial paper, which is company short-term borrowers. So this unprecedented level of federal stimulus means that companies should expect an unprecedented huge wave of law enforcement activity for many years to come. Let's move to the next slide, please. Thank you. So obviously a program that's received a lot of scrutiny, and we've seen as enforcement roundup a lot of enforcement actions, is the PPP program. Applications for SBA loans are submitted under penalty of perjury with representations regarding full truth and accuracy. You can see on the slide here that PPP loans are going to be audited, and the main areas of risk are whether the loan is necessary, size eligibility, the use of the proceeds, and the like. And SBA is going to want borrowers to consider these certifications. For example, PPP regulations have a requirement that 75% of the funds go for employee salaries and no more than 25% on rent, mortgage interest, and utility payments. Now, this 25% cap, notably on non-payroll expenses, is not included in the CARES Act itself, but was imposed in the regulations crafted by the SBA and the Treasury Department. I think there was some hope that in the May 22nd guidance, there might be some relief from the 75-25 rule, but the government has maintained that rule going forward, and so we still have to deal with that 25% cap. And the recently released guidance confirmed that if funds are used for unauthorized purposes, borrowers have to repay the loans and could be subject to liability for retaining those funds. As Sina has pointed out, the safe harbor period has passed. An area of certification risk is needs-based certification. And that's really where a company, if they want to convert a loan to a grant through the forgiveness process, that's really going to impose an obligation on the company to certify accurately. And as I mentioned earlier in response to our question, on May 22nd, the new rules that were issued made a statement that the SBA may review Paycheck Protection Program loans, quote, of any size at any time in the SBA's discretion. So that appears to walk back the earlier guidance that was referenced in the question before. Companies have an area of compliance risk, and this has to do with the quote-unquote necessity certification. And the language for necessity is, quote, current economic uncertainty makes this loan request necessary to support the ongoing operations of the applicant. And of course, that language includes the words uncertainty and necessary, and there's very little guidance as to what those terms mean. So there's potential compliance pitfalls there when you're when you're certifying uncertainty and whether it's necessary. There are specific calculations to be used in determining the amount of the loan. The May 26 guidance has some additional detail. There's a $100,000 salary cap for payroll calculations. Borrowers have to provide backup for their payroll claims. So you should take a look at that May 22nd guidance for the latest information. But again, the burden of compliance is on the borrower, on the company, not the lender and not the government. In addition to certifications around loan amount and the compliance issues around that, there are strict rules regarding the loan forgiveness, and there are statutory mechanisms that could reduce the amount of forgiveness depending on the borrower's actions during the 8-week period following an origination. So you should look carefully at those rules. On May 15th, in one of the many guidances, the SBA produced a schedule, sort of a sample schedule that borrowers can use to document their use of the funds. And that can be a helpful guide, and I would encourage people to take a look at that guidance, at that checklist or that schedule if you're planning to seek loan forgiveness. Next slide, please. There was a question posed in the chat about payroll taxes and whether the taxes themselves are included in the 75% calculation. That may be the case, but I'll have to check the guidance and get back to you. So if you want to send an email after the program, we can follow up. This next slide talks a little bit about the SBA loans and the SEC crossover issues, as well as an issue that we've seen raised in some commentary and news reports about online conferencing. Obviously, in this crisis environment, lending decisions are made very quickly. The government's going to be relying and is relying on the representations made by applicants. As I mentioned, this recent guidance has clarified that lenders have very minimal requirements to independently verify applicants' eligibility. It's really an as certified as presented. So representations made on applications could form the basis for civil and criminal exposure for statements that are later proven to be materially false. There are a number of items on the application. the total number of employees, the payroll expenses that if filled out incorrectly, whether mistakenly or intentionally, could lead to an investigation. Now look, most applicants aren't going to outright lie on these applications. The cases that Sina summarized, many of those involved what we would call obvious cases of lying, cheating, and stealing. Sort of classic fraud where you've really got fake representations with no underlying basis in fact. But most applicants are not like that. Most applicants are business people trying to make decisions, looking for these loans as an opportunity and these grant programs as an opportunity to keep their businesses afloat. And they're having to navigate, oftentimes without the benefit of counsel, rules that seem to be changing every day. That's where we're going to have problems in the future. Now, these PPP loan applications make it clear when you sign those applications that if statutes are violated, there could be problems down the road. The application actually identifies certain statutes. It identifies 18 U.S.C. 1001, which is a false statement statute, 15 U.S.C. 645, misrepresentation statute, 18 U.S.C. 1014, which is false statements to a lending institution. Federal prosecutors are also fond of using other charging statutes like the criminal false claims statute at section 287, the bank fraud statutes at section 344, mail fraud and wire fraud 341, 343, and criminal conspiracy 371. These are all in Title 18. Prosecutors regularly use these as sort of trusted go-to charging statutes. If there's an allegation that a loan might have been obtained through bribes or kickbacks, there could be prosecutions based on bribery statutes, such as 18 U.S.C. 2015. In addition, we have SEC enforcement. The SEC is ramping up enforcement related to the volatility of the market surrounding the COVID-19 crisis. There's already been a surge in SEC investigations relating to fraud and disclosure requirements by companies, including the possibility of private shareholder lawsuits stemming from that. Just today in Law 360, it was reported that the SEC is fielding a spike in what they call tips, complaints, and referrals. Tips, complaints, and referrals, they call them TCRs. And the SEC fraud, one of the fraud enforcement chiefs said that to date, the SEC has issued more than 30 trading suspensions and that they've seen a spike in TCRs. So it's something to think about. The SEC enforcement piece of this is critical. And if you're working with a company that's publicly traded, that's an additional layer of enforcement risk that you need to be concerned about. Before we move off this slide, a point about video conferencing. Obviously, right now, our entire economy seems to be run on platforms such as Zoom, Cisco's WebEx, Microsoft has a platform. And we've seen some news reports and some commentary that in the immediate aftermath of the sort of pandemic, as companies were considering whether to take aid and to apply for aid, that a lot of these sessions might have been, as we all know, these online platform sessions allowed for the recording of those sessions. We've already seen requests by law enforcement to companies for copies of those recordings. So if your company uses online video conferencing, you should consider developing a compliance program that establishes the do's and don'ts of when sessions should be recorded, because those recordings could be evidence in a future audit or investigation. Next slide, please. These next two slides, I want to briefly cover two very large civil enforcement tools that the government has. In addition to criminal remedies and civil enforcement remedies by the SEC, the government has the False Claims Act. And on the slide here, we have sort of the basic elements of what is a False Claims Act case. And this is a statute that government contractors are very familiar with. But companies that don't typically do business with the government may not have a lot of understanding about risk management. So if you do business with the government, if you present claims for reimbursement, those claims, if they're deemed to be false, and this is a civil statute, so it's a preponderance of the evidence statute standard, not a beyond a reasonable doubt. And it's a much broader standard of potential knowledge. It doesn't just include actual knowledge and intent to defraud, but it can also include reckless disregard, so a much sort of broader category of potential scienter. And what has happened is that these applications for PPP funds, when you take the money, and more importantly, if you seek forgiveness and you don't repay that money, that creates compliance issues and potential exposure around the False Claims Act. There's also what's called the Reverse False Claims Act provision, that if you knowingly withhold money that you shouldn't retain, you can have False Claims Act liability. Before we move to the next slide, 2 points about healthcare companies and lenders. As Justin mentioned, in addition to PPP, there are a series of grants that HHS gave to healthcare providers. There's an HHS relief fund, and you can go online and look at a database of healthcare providers that have accepted this money. Unlike loans that were applied for, some of these providers literally woke up one day and found money in their bank account, and then were asked by the HHS to certify that they were going to use those money. And this is really a whole different area of potential False Claims Act liability, and the certifications are the strings attached. And so healthcare companies that have received those funds, and they've come out in a series of rollouts and tranches, need to be mindful that their certification, attestation and certification around receiving and using those funds could create potential liability. And if you're a healthcare provider and you're currently involved in a billing dispute with Medicare or in an overpayment dispute with Medicare, if you're dealing with CMS or have other fraud allegations, you should make sure that you're mindful of those enforcement actions that you're dealing with in light of receiving additional funds. Keeping CARES Act money in violation of the government's attestation and certification requirements really could create the basis for liability under the False Claims Act. The other point you should be aware of is HHS for healthcare providers added a certification paragraph to all its relief funds terms and conditions, requiring certain additional certifications that relate to criminal and civil penalties. So you should take a look at that if you're a healthcare company. With respect to commercial lenders, federal agencies originally agreed to hold banks largely harmless if they relied on, in good faith, on borrower certifications and supporting documents. So it seems less likely that there'll be wholesale investigations of the banks themselves, but lenders should be mindful that they could be subject to investigation and prosecution if their own employees are alleged to have conspired with applicants to fraudulently secure CARES Act loans. After the 2008 financial crisis, again passed as prologue, there were investigations of bank employees that were alleged to have been complicit in obtaining fraudulent mortgages. Commercial lenders could come under scrutiny if government investigators uncover a significant amount of fraud associated with a single lending institution. So if they look at a lending institution, they appear to be a hotspot of fraud, that could subject a lender to scrutiny. So something to bear in mind. A lender shouldn't take 100% comfort in the fact that there's a limitation of lender liability. Next slide, please. The other powerful civil enforcement tool that I wanted to bring to your attention is what we call FIREA. That's the Financial Institutions Reform, Recovery, and Enforcement Act of 1989. That's a mouthful. It's called FIREA. This was enacted following the 1980 saving the loan crisis. It's a civil statute, but it was largely dormant for many, many years until the late 2000s. And as government prosecutors began bumping up against the statute of limitations to bring criminal fraud cases, they began to look to FIREA, a civil statute, as a charging tool. It's been said that the U.S. Attorney's Office Civil Division here in Los Angeles was an instigator of this. If you will recall the large-scale civil cases involving Countrywide, a successor, Bank of America as the successor in interest to Countrywide, a number of those Countrywide cases were actually FIREA cases that were worked jointly by the Department of Justice and the U.S. Attorney's Office. And some have said that the Civil Division Chief, Lee Weideman, was responsible for sort of dusting off that statute and using it. I don't know for sure if that's the case.
Okay, it looks like we've lost Vince again. I know time is starting to run out here. Let's see if I could close it out here after the FIREA discussion. Here on the third-party liability issue, COVID-19 enforcement, it does raise the specter of the companies facilitating the sale of exorbitantly priced product and providing means for the mechanism for others to engage in fraudulent activity may be exposed to potential civil and criminal liability. Oh, and here we've got.
Here we go. And once again, the vagaries of working from home, my apologies. And that's also probably a sign that we're about to go over time, so I'll pick up the pace. The third-party liability that Sina was just talking about is another significant area. We want to be mindful that in the case of this, we have actually some cases involving voice over internet protocol technology companies that have received basically letters from the FTC. We're also seeing consumer class actions, a very big area. One of the questions that we've gotten in the past is, can companies expect relief in terms of relief from potential liability? There's been some talk about passing legislation, federal legislation, to cap the liability of healthcare companies, employers, and internet providers, or not internet providers, but social media companies. And the Chamber of Commerce has commented that the wave of employee lawsuits that we're expecting could be a big area of concern. However, others have commented that they're in fact, we don't want to put consumer protection statutes to the side, and we certainly don't want a situation where consumer protection is not maintained. And so my view is that companies shouldn't hold their breath. We shouldn't hold our breath waiting for liability protection. We've got to be ready now. Employee lawsuits are another area where we can expect a big increase in litigation. Why is this? Employers, companies are in uncharted waters when it comes to occupational safety and the economy. Jobs are scarce. The plaintiff's bar has been on shutdown like the rest of the lawyers. And I do think we're going to see an uptick. One example that we saw recently is a Superior Court case filed against the dealership based in Pasadena. The ex-sales manager filed an action. He was apparently terminated at some point. He filed an employment action alleging that he suffered a backlash and was fired after complaining that management failed to take steps to protect employees and customers during the COVID-19 pandemic. And so he accuses the company of retaliation, violation of the California Family Rights Act, and discrimination. So in addition to government enforcement litigation, civil and criminal, we also have an increase in private litigation and class actions. Next slide, please. And this is a slide about class actions. I won't go through and read these. I know we're tight on time, but we've seen some of these advertised in the media. Class actions against Carnival Corporation, against educational institutions, against Amazon for price gouging. And I think that we can expect a robust number of class actions ranging from consumer frauds to employment claims based on layoffs, financial losses, and the like. I think this is just inevitable. Next slide, please. One last point before we close to some practical guidance for companies is a virtual town hall that was held last week. It was a virtual town hall that the participants were the chief of the DOJ fraud section, the senior deputy chiefs of the fraud section of the Department of Justice, the chief of the SEC's FCPA unit, Foreign Corrupt Practices Act unit, and the chief of the FBI's International Corruption Unit. They did a virtual town hall, and like oracles, they proclaimed that yes, there's been a slowdown in some enforcement. Not having access to grand juries and not having access to in-person interviews has been problematic. It has hampered investigations. However, they made it very clear that the FBI is able to get search warrants pretty easily. They can use a remote conferencing with judges. They're doing interviews and proffers via phone and teleconference, and they made it very clear that the healthcare fraud unit in particular is looking at schemes where persons are seeking to exploit the pandemic, where they're offering free testing in an effort to obtain personal identifying information and billing information for Medicare beneficiaries for supposedly unnecessary services. The SEC has also developed a steering committee and is coordinating their efforts with federal and state agencies. And I mentioned earlier about parallel proceedings. We can expect parallel proceedings between criminal and civil investigators at the SEC. And during the town hall, these enforcers said that the current environment is ripe for securities violations and market manipulation. And so that's something we wanted to share with you. Last slide, please. This is the final slide. And obviously, our sort of message here is that we are moving beyond the obvious cases of lying, cheating, and stealing. And we're now going to be looking at cases involving the gray area, where companies acting in good faith are going to be audited and investigated in situations where they might have unintentionally or unknowingly made statements that turned out to be not accurate. Nearly 75% of all the loans in the first PPP wave were for less than $150,000, and 90% of the second wave of loans were of small size. And this suggests that most of the applicants were small businesses that don't have extensive compliance teams, don't have in-house counsel. So what's our message? Be ready, and tell your clients to be ready. Companies that take government money have to be proactive in documenting their eligibility and their compliance with government requirements. I have sort of a 7-step process. This is by no means legal advice. This is just a way to organize your thinking. The first step is work with clients to get a firm grasp on the specific criteria to qualify for eligibility for the program. A practice pointer, unfortunately, the May 22nd guidance doesn't give us any further clarity on eligibility, and so we have to use our common sense and follow a rule of reason in advising clients. The second step is to understand the specific conditions for receiving the federal funds. What are the attestation requirements? What are the certification requirements? The third step is to carefully document the decision itself to apply for government aid. So, for example, document the company's current business activity and how it was negatively impacted by the pandemic. What was the downturn in the business? Document that. Keep track of the business projections that were made in deciding to take out the loan. What were your projected payroll needs? Document that there was no alternative source of liquidity. Document those things as part of this third step. Fourth, carefully document how you spent the money. Employee counts, compensation levels. Keep contemporaneous receipts and logs. After the fact records are viewed more suspiciously by investigators than contemporaneous documentation. In terms of practice pointers, the PPP loan forgiveness application posted on the May 15th website alert does give a detailed schedule. I think that's helpful. One thing that we get a question is about document retention. And as I understand it, the May 22nd guidance indicates that borrowers have to retain their PPP documentation for 6 years after the loan is forgiven or paid in full. So 6 years is a long time. Be sure to document make sure that you adjust your client's document management and destruction policies accordingly. Fifth, if you don't already have them, develop written standards for employees to follow. Sixth, train your relevant employees on the relevant standards. And seventh and last, create an internal monitoring system that regularly tests whether the company is complying with the rules and regulations on the government programs that the clients accepted money from. It's been said that money is fungible, but government investigations follow the money in a straight line right into the business and right out of the business. I've seen that as a prosecutor, and I've seen that as a defense attorney. So following good compliance practices now will help companies with any audits or enforcement actions in the future. And as the old adage says, an ounce of prevention is worth a pound of cure. So that is our presentation. Our email addresses are there. I do encourage, if you have questions or want to talk about these matters further, reach out. We're happy to consult. And we're very grateful for the opportunity to have made this presentation and to work with the Beverly Hills Bar Association. And so with that, we'll thank you for your time and thank you very much for listening. Bye-bye.